I want to say how pleased I am that you came out to be a part of this panel, because what is happening in Barbados right about now is pretty significant, and the more people who come out and familiarize themselves with what's going on, the better it is. A lot of what happens in Barbados by way of industrial relations is pretty much tradition and hearsay. And so you may know somebody who is going through a situation at work, and you may advise that person based on what you think is right, based on what happened in another workplace that you know of, and so on. And that may not necessarily be accurate. In fact, up until now, a lot of what has happened in various workplaces has happened by tradition, customs and practice, we call it. So, and collective agreement and so on. So what happens in your workplace may not necessarily happen in somebody else's workplace because they have a different agreement. We needed to standardize that, and so we have moved to put legislation in place. Prior to this year, this recent term, the legislation in Barbados all dated back to the 1950s. Most of the legislation, the labor legislation on the books, is back to the 1950s. And as you can well imagine, there have been a lot of changes in the industrial arena from the 1950s to now. We're not even looking at the safety and health today, but I can use that as an example. We've just proclaimed the Safety and Health at Work regulations. That replaces the Factories Act from back in, that's probably before the 50s, that was the 30s, wasn't it? That goes way back, but that's the Factories Act. And we just replaced that because back then, a lot of the work that was done in factories. And now we know the workplace has changed. The workplace now, we have offices, and many people are even working from their own homes. So that whole dynamic has changed. So we've had to change the legislation. That is also what's happening here with the Employment Rights Act that we're speaking about. There's also legislation that we're doing in the ministry now, the sexual harassment in the workplace legislation. There's no legislation that speaks to that, but we all know that these are things that a lot of people deal with. Some of us may have dealt with it ourselves. We know people who've dealt with it, sexual harassment in the workplace. And that's a whole other discussion, and I trust that when we get near to bringing that to Parliament, which should be sometime soon, that we can have another session on sexual harassment and what exactly is sexual harassment. While a lot of us can identify clearly what certain things are, certain horrific things are, we say that's sexual harassment, there's some finer points in the definition that we need to make clear, but that's for when we get to the discussion on sexual harassment. Anti-discrimination in the workplace. That's something that we're also working on now, because that is something that, while we've always had discrimination, because human beings tend to discriminate against people who are in some way different. But now we're going to have to bring legislation to address that, because it is a matter that we are seeing more and more in the workplace. The Employment Rights Act is, as I said, we just proclaimed that legislation in April of this year. I had the honor and privilege of debating that in the lower house in May of last year, and I've been limited to speak for 15 to 20 minutes, I'm told, but let me warn you, I spoke in Parliament for 3 hours, so but I will not do that to you today. So being able to condense my presentation this evening to 15 to 20 minutes, let me just say that there's a lot in that legislation, so one could speak at length. I could speak for half an hour, and each of these could speak for half an hour, and we probably don't even touch everything that is in the legislation, because it really is very wide-ranging what we are attempting to do in the legislation. What is happening now in the workplace, and one of the reasons why I was particular to push this bit of legislation, since I became the Minister of Labour, I'd had a lot of opportunities to meet with workers, to meet with employers even, to meet with the unions on issues especially pertaining to where we have foreign companies or companies in Barbados that are now taken over by foreign interests. And so they've come to Barbados and they have different ways of doing things. So we have companies here from Trinidad, we have companies from Jamaica, we have companies from the United States, we have companies from England, and from so many other places operating here in Barbados, and they have different ways of doing things. Of course, when they come to Barbados, the first thing they do, and their lawyers advise them, check our laws. So they study our laws. And as I said before this, there was such a paucity of legislation that spoke to employment rights that when they checked the legislation, they realized, you know what, we could do just about anything, because most of what happens in Barbados happened prior to this by custom, by practice, by this is the way we do things in Barbados. And so the union will get on their case and say, no, that is not how we usually do things in Barbados. But we realize that that can't fly anymore. We can't just say that's not the way we do things. We had to make sure that we got this legislation, because when, especially foreign interests, when they are ready to deliberate and to determine what they have to give to their staff and how they have to treat to their workers, they're looking at the legislation and they're going by the book. They're not concerned with how we are accustomed doing things and how your cousin know that it was done when they work at this company under former management. That has no concern. That is no concern of theirs. They are only interested in what is written in the law. And so we had to make sure that we had something written in the legislation. So there have been changes in the work environment. I'm pleased to say that as we developed this legislation, which was a long time in the making, I didn't just come and start this legislation and bring it to the books right away. This legislation has been in the making for about 20 years. Because as the workplace changes and as it affects people, you want to make sure that you get it right. And even after it's passed, we know that there may be need to amend other things. Because it changed how things happen in the workplace, we had to meet at length with not only the workers' representative, but the employers' representative, because it meant that the employers have to change the way they manage their business. And you know how it is, you don't want to change the way you're doing things. And so we had to try to encourage them to see why we needed to do certain things, and also to try to make sure that the changes weren't too onerous on business, that they met the needs for the workers, but that they weren't going to disadvantage in any significant way the employers. It has meant that employers have had to change the way they've done things, but hopefully it hasn't put them out too much. And so I want to thank the social partners, because with the help of our social partners, the workers and the employers, we've been able to negotiate back and forth until we came to an understanding of what is happening here. We have in labor circles a discussion on decent work. What is decent work? And when some people hear that term, they get all up in arms. They say, but there's no such thing as work that is not decent. But when we use the term in labor circles of decent work, we're speaking to work that not only provides opportunities, where there are opportunities to work and opportunities to make an income, but also where there's social protection, where there's social dialogue, where employers and employees have a chance that they can discuss matters, and where there are fundamental principles and rights operating in the workplace. And that has governed all the policies, all the legislation, everything that we've done in the workplace. We're now also looking at domestic workers and putting in place legislation for domestic workers. Some of what happens in the employment rights does cover domestic workers, but as many of you know, there isn't a lot of legislation to cover domestic workers. There's a minimum wage for domestic workers, but there isn't much else for domestic workers. And so we're now actually meeting with domestic workers to ensure that we can ratify the ILO Convention on decent work and move to putting the necessary legislation in place to protect domestic workers. Because our workspace, as I said, is not just a factory, it's not just an office. We're looking at all types of workplaces, which include the domestic arena. Now, some of the things that will happen in the Employment Rights Act, and as I said, I could speak to each one of these at length, and my colleagues here can as well. And I said it does affect the way that business actually happens and the way employers have to conduct their business. So, for example, the statement of particulars. That is something that has been introduced in the legislation. The statement of particulars, when the legislation was proclaimed in April of this year, as I said, it was passed, but then it had to be proclaimed by the Governor General, and it was proclaimed in April. And after April 15th, we've given employers an additional 6 months, so that takes them to October, to have to put all the paperwork in place, because there is some paperwork that they have to do. Now, as I said, we don't want to make this too onerous for employers, but a lot of this now can be done on computers, because most places are not writing out contracts by hand, and you're not sitting typing every one by hand. If you generate something on a computer, it's easy. You can do a standard form on a computer and just make the necessary changes for the individual and have those things printed. So it's just about bringing best practice into the workplace. So this statement of particulars, I'm particularly encouraged, or I was particularly impressed on the need to have this bit of legislation, this bit in this legislation on the statement of particulars. What it says is that when you're working for somebody, they have to give you a piece of paper that says who you are, who you're working for, and what you're supposed to do, and what you're supposed to get paid to do it. So when you have your statement of particulars, it's supposed to say that you, with your name, your address, date of birth, and so on, you are working for and you are hired by Mr. B of such and such a company, whether it be the holding company or whoever. This is who is hiring you, and by putting it on that piece of paper, that person is responsible for paying you. That becomes a legal document. That person is responsible now for paying you. That person is responsible for all the issues that you have to deal with, whether they have to give you notice, whatever it is, that person becomes responsible. So that's the statement of particulars. It says what hours you're supposed to work. It says where you're supposed to work, what your duties are supposed to be, and things like that. And that protects both employer and employee. Because it means if I put it down that I'm hiring you to do A and B, when you don't at such and such a time, when you don't show up at such and such a time, or when I look around and you're not doing A or B, I as the employer, I could say, but hold on, you are not keeping up with your end of the contract. Likewise, you have there what you're supposed to be doing as well. And it means that you as the employee can say, well, listen, no, I wasn't engaged to be working over there, because my terms, my particulars say I am working here Monday to Friday. I'm not working here Monday to Friday, and then Saturday you're sending me down to your whole town store. That was not part of the agreement. If we want to change that agreement, then we can change that agreement by mutual consent. But that is not the agreement. And they can't fire you then because you said that, because that is what is in your statement of particulars. And there are a whole lot of other things that can go in to the statement of particulars. But as I said, I'm excited about that because it means that you can clearly see what it is you're supposed to be doing. Then there's the itemized pay statement. That is something else I'm thrilled about, because it says I'm supposed to be getting $300 a week, and what is supposed to come out, my national insurance is supposed to come out, my PAYE is supposed to come out, you're supposed to take out, I asked you to take out $20 to send to court, I asked you to take out my union dues, etc., etc., etc. And when I get my pay statement, I am not just getting an envelope with some change in it that I have no idea why it is I believe I work for $300 and I'm only seeing $120 in here with no explanation. There's a pay statement that says $20 went to courts, this amount went to national insurance, that amount went and so on. Because the other thing is, and we've seen a lot of this, persons are terminated, they go to national insurance for their unemployment benefit, and national insurance has never heard of them, because nothing has ever been sent to national insurance. But you know that when you get your money, your pay packet, it's not all that should be there, because you were told, well, they took out for national insurance, but they never submitted it. By putting it in writing, you now have a case. You could say, but look, you have been taking out. So now the national insurance and whoever, your lawyer, the Labor Department, whoever, can now argue for you that the employer has been taking out this money, and therefore something should be there, and if they haven't put it in, they now owe national insurance. So things like that are for the protection of the employee. An employment record, if you're terminated, you should get a record saying you worked at this place for X amount of time doing certain duties. Sometimes people are terminated, they want to move on. The new employee or the prospective employee asks for documentation on what you've been doing, and the employer, your former employer, says, "I've got the time for that." And so you can't move on. Now, when you are terminated, you're supposed to have an employment record that speaks to what duties you were doing before and how you've been doing them. There also needs to be a system of performance appraisal, and that is important, because when they give you your contract, your terms and so on, they should tell you how you're going to be appraised periodically. So that when your employer says to you at the end of 6 months, listen, I'm sending you a warning because you have not been doing A or B. And that's why I said it protects employer and employee. Because when your employer says, I have to give you, this is a warning, you're not doing such and such a thing. Because we understand now that there's going to be a system of assessing your performance. That is important. So that the employer can't just get up one day and say, man, this is 3 years now, I'm tired of you and this. Every morning I expect you to come in here at 8 o'clock and you showing up in here 10 past 8 and I'm done with you and send you off. Can't happen like that. There has to be a system of appraisal and feedback where they tell you, listen, you're supposed to be at work for 8 o'clock, not 10 past 8. And you get that feedback, and of course, after you get repeated warnings and so on, then you can be made, you can be terminated. There's also supposed to be a notice period. The legislation speaks to the amount of notice that you're supposed to get based on the length of time that you've served in a particular company. So that is also clear in there. And then it speaks to the tribunal, and that is something else that I'll just speak to briefly because I suspect my time is about up. Yeah, the tribunal, what normally happened is that you had a dispute with your employer, they let you go, usually it's in cases that they've let you go, or for whatever reason you're not, what they're taking out of your salary you're not satisfied with, and you go to the Labour Department, and the Labour Department says, no, this doesn't sound right. But because they didn't have the force of law, all they could do is call the employer and say, this is not how we do things, this is not right, you need to address this. And they will have to probably get on their case time and time again, and hopefully something can happen. Sometimes the employee can bring a case to the court, but very often our employees don't, and the ones who go to Labour Department, very often, they don't have money to get a lawyer, then they're frightened by the whole idea of going to court. They believe, well, look, if I take Carl Williams, for example, and please, I'm not saying I have any cases, but just for example, you could see a poor little old man deciding he's not satisfied with what he got from Carl Williams, and you say, well, listen, in the Labour Department, our hands are tied, you're going to have to take Carl Williams to court. The little old man can say, well, no, sorry, I don't think that I will really get through anywhere because that's not going to, you can just imagine the trepidation. They're not going to take that to court. But now we have the tribunal. So you go to the Labour Department, we have legislation, the Labour Department can now bring the legislation, bring the law to the employer and say, this is what you need to be doing. They can try conciliation and so on, and if that doesn't work, we now have a tribunal that is established by law that they can now say this matter can be referred to the tribunal, and the tribunal will hear your matter. And you can go by yourself, you can go with your attorney, you can go with your union rep, you could go with a friend, you can go with whoever and have your case heard before the tribunal. So it is establishing rights. And finally, let me just say this. I said something like this at a graduation at People's Cathedral recently, and I think the press carried just a little snippet of it and folks got it wrong. Those who were present understood what I was saying, and afterwards they did agree with what I was saying. With rights come responsibility. The legislation provides for rights for workers. And we want for workers to have rights because we want that when you go to work, you are comfortable in your workplace. So we have employment rights, we have sexual harassment, we have safety and health, we have discrimination legislation, all of that. So when you go into the workplace, you know that you are protected and you have certain things have to be in place for you. We want employees to be comfortable in their workplace so that they can be productive. And Barbados, we can raise the level of our products and we can raise the level of our services. It is something that, as much as we talk about training and education, when we get into the workplace, we have to work. We are doing certain things, including legislation, to ensure that when you go to work, we got your back. But when you get there, you have to do the work. That is most important. You have to do the work. I think that is enough for me at this point. I hope that we would have stimulated, by the time we're done with our presentations, that we would have stimulated enough discussion, because I'm really keen that you understand what your rights are, or that you be creating you a certain thirst for knowledge, for more of the Employment Rights Act, and you can come to the Labour Department, you could call the Labour Department, you can get legislation. Somebody is actually waving the act there at me. It is online as well. So you can get the legislation, read this legislation. If you're not comfortable reading all the legalese, come down to the Labour Department. Also the workers' reps, the employers' organizations. There are many organizations that have, that can give you, in ordinary speak, the legislation as well, the main points of the legislation, so that you could know what your rights are. That is important. We've changed how we've done things, but you need to know what those changes are. It's not what you were accustomed to 10 years, 20 years, what your aunt was accustomed to in her workplace, what your big sister was accustomed to in her workplace. We have changed how we're doing things in the workplace. Thank you.